Now we're going to deal with our third and final branch of government, and in fact, the final chapter that I'm going to make these videos for. And it's going to be on the federal courts. First, let's talk about the judicial system generally. There's two types of cases. Criminal law, this is where the government has charged somebody with a crime, and if found guilty, that person can be punished by jail time or a fine or probation or something like that. Probation, yeah. And civil law, this is where two people sue each other, or it could be it could be corporations, it could be states, it could be the federal government. And this is where two entities of some sort file suit, one against the other or both against the other, and and whoever wins could be awarded damages from the other party. Nobody goes to jail in civil law cases typically. This is more about making restitution or financial payment because of something one of the parties has done. Most cases are tried and resolved in state, not federal courts. The federal courts are actually a very small portion of the legal system, but we're going to be talking about the federal system. Things like burglary, divorce, speeding tickets. These are almost always going to be handled at the state or the local level. Litigants are the people involved in the case. The person accused of the crime is a litigant, as well as the Attorney General's office. The two people suing each other, they're all litigants. The plaintiff is the party bringing the charge. In the case of criminal law, it's the government. In the case of civil law, it's whoever filed the suit. The defendant is the party of being charged. The jury, which is normally 12 people, but not always. There are certain, in some places in the country, for certain crimes or whatever, you might have a jury of 6 or some other number. And they will decide the outcome of the case. Now, as we talked about back in Chapter 4, one side has to request a jury. And you have to be given a jury. That's one of your rights. But if neither side requests a jury, a judge can simply decide in the case without a jury being involved. If you're going to sue, you must have standing to sue. That means that the plaintiff must have some serious interest in the case or must have sustained some direct injury in the case. We talked about how Chief Justice Taney threw out the Dred Scott case, ruling that Dred Scott, being property and not a person, had no standing to sue. We also talked about the Newdow case from a few years ago, where the man tried to sue, saying they couldn't make his kindergarten daughter say the Pledge of Allegiance because it had "under God" in it, and they ruled that since he only had joint custody of his daughter and not full custody, he didn't have standing to sue. It was a controversial way to approach the case, but it kept them from having to make a decision they didn't want to make. Suits have to be justiciable. They have to be capable of being settled as a matter of law. A court of law cannot decide who's prettier. A court of law cannot decide who's morally right and morally wrong in just kind of a philosophical debate. It has to be something where law can be applied and a decision can be reached. It has to be justiciable. Groups will use the court to try to change policies. We talked about interest groups filing cases. A great example of this, of course, is the Brown v. Board of Education case, which was brought by the American Civil Liberties Union and the National Association for the Advancement of Colored People. You could, we'll talk about class action groups in a minute, but large groups can, as well as individuals, can bring cases. When cases get to the Supreme Court, you could file an amicus curiae brief. We mentioned these in interest groups. Amicus curiae is Latin for friend of the court, and it's basically giving advice to the court on how they might decide the case. If you're influential, if you're important, if you're the U.S. Chamber of Commerce, which is a powerful pro-business lobbying group, or if you're the National Rifle Association or something, or if you're just a particularly well-respected mind, if Bill Clinton filed an amicus curiae brief, the court will probably read it, and they may even take it into account. In fact, some big court decisions have essentially been amicus curiae briefs that the court basically just made their opinion based on that brief. There are 800,000 lawyers in the United States. Lawyers are also called attorneys. The Legal Services Corporation is a group of lawyers that helps the poor. But access to quality lawyers is not equal. One of the things we realized in the O.J. Simpson case, many people feel like O.J. Simpson committed the crime, but because he had an excellent legal team, which he could pay for because he was rich, he was able to escape punishment. And one of the lessons people took from that is how many poor people get accused of crimes, didn't do it, and don't have outstanding legal teams, but end up being convicted because they can't afford good lawyers. You're guaranteed access to a lawyer, but you're not guaranteed access to a good lawyer or a lawyer who's particularly interested in your case. And so there are many critics of the legal system who say that it favors the rich at the expense of the poor.